Neuberger versus York, challenging a will after it has been put into effect. Citation: Neuberger versus York, 2016, ONCA 191. Facts: Chaim Neuberger, a Holocaust survivor and wealthy businessman, left a will intending to share his wealth equally between his two daughters. Chaim created two wills, one in 2004 and one in 2010. The 2004 will took all of Neuberger's assets and divided them evenly between his two daughters. In 2010, Neuberger created a new will giving his original company to one daughter and his newer business to the other. When the will went through, instead of going through a balancing process, the capital stock of each company was distributed directly to the sisters. The issue that arose prior to Mr. Neuberger's death is, Mr. Neuberger lent some of his money back to one of the businesses, greatly increasing its worth. Consequently, this left one sister with a company worth nearly $13 million more than the other sister's company. Eddie, the sister with the less valuable company, took her case to the lower court in an attempt to change her father's will and have his assets distributed evenly. Eddie argued that her father was not in the right state of mind in his old age to understand the fine print of his will. A geriatric psychiatrist confirmed Eddie's argument to be true. Eddie further claimed that Mr. Neuberger's lawyers and accountants assisting him in creating his will did not explain the effects of the changes made in death. Eddie also contended that her father's intentions for the will were to be fair and equal, and they were not put into effect. In the lower court, the judge's motion denied Eddie the ability to change the will. The judge felt Eddie accepted aspects of the will that were convenient for her, yet is arguing what is not convenient for her. The lower court also dismissed Eddie's case because she did not file her complaint within 2 years of the will being received. Eddie proceeded to the Court of Appeal for Ontario, also known as the ONCA, to have her case further assessed. Decision: The ONCA decided that Eddie should be able to proceed with challenging the will, and if she's successful in doing so, she may reverse the effects of the 2010 will. Issues: There are two issues of this case. Firstly, if the intentions of the defendant's father had, when creating the will, were not employed in the result of the will, does this validate means for changing the will? And secondly, although Eddie failed to file her case within 2 years of the will being instated, is this valid means for dismissal of her case? The ONCA's rationale of Issue 1. Wills are not supposed to be changed. However, the outcome of a will is not always in the best state of its tester. The duty of the court is to look at each case individually and oversee the law when necessary. The court cannot make a decision based on law before analyzing the case. As of now, the will cannot be changed, although if Eddie makes a compelling case that the court feels is justifiable, the will may be changed. Analysis: Although once a will is put into effect, it can no longer be changed, there are several situations where this could be an issue. In the situation of the Neuberger sisters, it was understood that the goal of their father's will and the assets they would be given was intended to be fair and equal between the two women. It is evident that the will did not end up working out this way. It is more essential that the goal or intent of the will is what the outcome brings rather than what is in writing. If the court sees reason to change the will, it should be allowed. The court is allowed to overrule certain laws on a case-by-case situation. In Eddie's case, the quality of her evidence regarding her father's will and her reliability should grant her leeway in changing her father's will. Survey question: It is impossible to know the exact intent of one's will after the person had passed. If the recipients of the will's assets do not feel the will's execution was in the best interest of the will's testator, do you think changing the will is acceptable? Please answer with either yes or no.